Hi everybody, I am Ahmad Torabi, PhD in law, and this is Contract Law Teaching Online, Lesson 2. In the last session, Lesson 1, I talked about the importance of contract law among other branches of law, and in this video, I'm going to talk about two things. First, I'll talk about the legal framework, the legal structure in which contract law is going to be studied, and then I'll talk about basic elements of any simple contract. So let's go to the first point, to the first part, which is legal framework in which contract law is going to be studied. We study contract law in the legal framework of common law system. You may know that common law system is mostly based on precedent rather than any statute, rather than any legislation. Common law is usually applied in many countries, but mostly in Western countries such as United States, United Kingdom, Canada, and Australia. Of course, each one of those countries has its own features, has its own uh, specifications. Common law is usually uncodified system. It is set of rules that are created by judges over years, are created by quasi-judicial courts such as arbitration boards due to the expression of written opinions. The defining feature of common law is that it is presented by precedent. Precedent is the base of common law system. Judges follow such precedents. It's not unusual to find even 100-year-old cases which are still sources of new legislation, which are still sources of new statutes, which are still sources of new doctrine. Even while interpreting a law, we use precedent. So, judges have significant role in shaping, forming, and expanding common law system. And I should add something, and that is, we have a statute in common law system. We have a scattered law in common law system, but actually, common law system doesn't rely on them. Common law relies on judicial decisions. So, in contract law, because we are studying contract law in the legal framework of common law, I would say that whenever a point of contract law is stated, it is usually based on a legal decisions, on a judicial decisions in a case brought to a court. So actually, whenever I'm talking about the point of contract law, we have to refer to many earlier cases. So you'll see that there will be some legal cases that will be studied while we are studying points of contract law. So actually, this is the part one of this video. In brief, I would say that we are studying contract law in the legal framework of common law, and uh, the defining feature of common law is that it is based on precedent rather than statutes, rather than legislation. Okay, now let's go to the second part of this lesson, which is about basic elements in any simple contract. Actually, we have five basic elements in any simple contract, which are offer, acceptance, consideration, intention to be legally bound, or intention to create legal relation, and the capacity. Of course, there are some writers who have mentioned other basic elements such as legality and certainty. but I'm not against them. But actually, I want to say that there are, in brief, we can say that there are five basic elements. Offer and acceptance are the two most basic ones which create agreement. So whenever we have offer and acceptance, it means that we have agreement at least. But not all agreements are contract. Not all agreements are contract. In order to make a contract, we need more than this. We need more requirements. Whenever we have some other elements, it means that we are going to make a contract. This is a distinction between agreement and contract. In an agreement, we have offer and acceptance, but in order to make a contract, we need more than this, we need more requirements. I know that uh, in normal life, these two terms are exchangeably used. Mostly you see that, for example, uh, they say we have lease contract, sale contract, or lease agreement, or lease sale agreement. And you see that these terms are interchangeably used. But in law, when we are talking in law, we have to use exactly any word in the right place. And I want to say that here is a distinction between agreement and contract. In an agreement, we have offer and acceptance, but in order to make a contract, we need to more than this. We need other requirements as well. And those requirements are consideration, intention to be legally bound, and the capacity. So now you know that offer and acceptance at least make an agreement. In addition to offer and acceptance, both parties must uh, make something to the bargain, must contribute something to the bargain. This contribution uh, is called consideration. So without consideration, in fact, indeed, we would say that there is no contract. Consideration, I would say it is the base of any contract. So unless a promise is put into a deed, it would not be binding upon a person who made it. And unless the other party has contributed something to the bargain, it would not be binding upon that person. Uh, so both parties must contribute something to the bargain, which is consideration. Uh, Further, in addition, I would say that both parties must intend a sort of bargain that each one intends to make that bargain. I want to make a lease contract, you are going to make a lease contract. I want to make a sale contract, you are going to make a sales contract. Intentions must be similar, must be in a way together. Intentions must cover each other exactly. So this is the point. When we say that uh, both parties must intend to make a contract and intention to be legally bound, it means that I'm going to make this contract because I want to be bound by uh, legal overtones, by legal effects of this contract. I know exactly what I'm going to make. I know exactly what I'm going to write. I know exactly what I'm going to sign. So this means intention to be legally bound. I know that I'm going to be bound by the effects of this contract, by the effects of this document. So up to now, you see that there are four basic elements in any simple contract. In addition, I'm just talking about these basic elements in brief. Now, in the next lesson, we'll talk about each one of these elements in detail. So now let's go to the fifth basic element, which is capacity. What is capacity? Capacity means, indeed, in principle, the law protects of the infirm. The law protects of the weak. The law protects of those who are less than full contractual capacity, like drunk, like young, like those who are under influence, like mentally disordered. So whatever you see, a young is signing a contract, that contract would not be valid. Whenever a person who is mentally disordered is signing a contract, this would not be valid contract. And so I would say that the fifth requirement for any simple contract is the capacity. Everyone who is one party of the contract must have full contractual capacity. So these are basic elements in any simple contract: offer, acceptance, consideration, intention to be legally bound, or intention to create a legal relation, and the capacity. These are five basic elements in any simple contract. I will talk about